The Honorable F. Grant Wallace, Judge presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Hey, good morning and welcome to an oral argument session of the 5th District Court of Appeal. I've already been introduced. To my right and your left, I also have joining me on the panel Judge Adrian Soud, and to my left and your right, Judge Paige Kilbane, and we will be working through these two cases that are set for OA. I am going to assume that the appellant would like 5 minutes for rebuttal. Unless I hear differently, please be sure to advise me if you want to adjust that at all when you step up to the podium. And I just ask that before we get started, if anybody has any devices that make noise, if you please put them on mute, or even better, just turn them off. That way it won't disrupt the parties when they're making their presentations. So the first case we have on the docket is Bowles versus St. Mark's Pond Industrial, and Mr. Lewis, you may step to the podium when you're ready. And is 5 minutes good? Yes. Okay.
May it please the court, Your Honors. My name is Richard Lewis, and I represent the appellants Michael and Daria Bowles in this case. This appeal is about a simple 2-page real estate contract, a contract that all parties consistently referred to.
Mr. Lewis, was it a contract or a letter of intent?
It is our position that it was a contract.
Is there a difference if it is a letter of intent?
There is a difference, and in this particular case, at trial, which was admitted into evidence, is on the record in this case, the parties had an initial letter of intent that looked like a traditional letter of intent. It was a letter from my clients offering to their clients to enter into a contract at a future date, and it stated a per acre value, and it actually had a map attached to it, which was created by Greg Jones in this case. And the map was for 120 acres originally. Because the way this property is situated, it contains a conservation easement in the center of the property that is about 50 acres that's already conserved and cannot be built upon. North of that is the 65 acres that my clients, the appellants, sought to purchase. They originally had a letter of intent that they proposed, which had a provision in the contract that said at a future date they were going to enter into a contract if these terms were acceptable to the appellees. The appellees came back with a contract that looked more similar to what is before the court today, which is the binding intent to purchase and sell agreement. And it had most of these same terms, but instead of the lease in lieu of closing that's on page 2 of the contract, it actually had an automatic quitclaim provision that if the property did not close by January 7th, my clients would automatically receive a quitclaim deed. Then that contract...
Mr. Lewis, can you focus specifically on the description of the property? I believe that's probably the majority of the discussion, at least in the briefs that were filed, as far as there was never any specific description by meets and bounds as to the identification of the property that was the subject of the agreement.
Sure, and just to close my argument or close my facts on the last, the third contract is the contract which we're here for today, and that contained a lease in lieu of closing if the closing did not occur as opposed to a quitclaim deed. And that's the contract that everybody signed in this case. But in this particular case, the legal description is contained within the contract itself. If you look at the top of the contract, it states, it is mutually understood that the seller is in possession of certain remainder land, and it has remainder land in quotations, and then property in parentheses described herein. And then if you go further down on the page, it contains property description, and it starts to describe that property. It contains 65 acres within the northwest part of parcel ID, and then it has the parcel ID number for St. Johns County, Florida, as indicated on the attached maps Bowles purchased proposed purchased area. It has a map attached to it, and the map has a red outline of the 65 acres that was proposed to be purchased by my client. And it even has the call points and the distance points. This map and this contract were created by Greg Jones in this particular instance. It says exact meets and bounds to be determined when the industrial park sites on the north side of this property have been finalized.
What was the date for the finalization of the industrial property?
Well, that date for the finalization of the industrial park sites is in dispute, or was part of the dispute in this case. We have an email from Greg Jones that predates the entrance of this contract, dated December 14th, 2020, where he emailed the engineer in this case, that was Gulfstream, Matt Latte, and he told them, we want to set aside the 5.5 acres on each side of the road. If you look at the map attached to the contract, there's a road that dissects the northeast corner of this particular piece of property, and that contains approximately 11 acres surrounding that, and that was proposed to be the industrial park sites. That's what the appellees told the appellants in this case, is where the industrial park sites were to be located. That's where Greg Jones advised the engineer in his email that's on the record on December 14th, 2020, where the industrial park sites were to be located. And then he states the rest of the land is going to be mitigation bank. There is no requirement in Florida law that a legal description actually contain a meets and bounds description. There can be all types of descriptions, and parole evidence can be used to define where the property is going to be located, as long as the parties intended to apply to a particular piece of property. The Florida Supreme Court has actually found descriptions similar to this to be binding and to not be ambiguous, which this court found that this legal description was patently ambiguous.
Was the extrinsic evidence that you attempted to introduce the IME survey?
Yes, the IME survey, that's the surveyor that my clients hired to determine
Was
where
the
the
IME
property...
survey consistent with the original diagram or picture that was taken of the overhead of the property?
Yes, if you look at the IME survey and you look at Exhibit A to the contract, that's what we called it, or the parties called it during the course of the trial, was Exhibit A to the contract. If you put those two side by side, which I actually did in my brief, they look almost exactly similar. There's no particular...
Looking almost exactly similar is not
Well,
looking...
the survey...
Sorry, hold on. Wait
Sorry.
1 second. Looking almost similar is not the same as identically similar.
The reason that there is a difference between the survey and Exhibit A that's attached to the contract is because Greg Jones created Exhibit A using a computer, and the surveyor actually went out and did the field work and found the monuments on the ground. Additionally, the industrial park sites to the north at that point had been surveyed. So we had the northeast boundary line between the industrial sites and the mitigation bank. So with using that survey, that extrinsic evidence, he was able to determine what that northeast boundary was. So it was more specific than the Exhibit A on the map. And the court even notes in his final judgment that the difference between the survey and the map is approximately the court notes that the map is about 0.098 in acreage difference, and there's a 40-foot difference. So the difference between the two maps is almost insignificant when you consider the fact that the surveyor actually went out and did the field work, and the other map was created on a computer.
So you're taking exception with the appellee's position that we have an inconsistency of the total acreage. I guess you're admitting that there is an inconsistency with the total acreage and that the boundaries are inconsistent, as well as the shape of the property as depicted by the overhead. Is that correct?
The only inconsistency is that northeast boundary, which at the point of the survey was defined at that point because the parties the Applees had entered into a contract to sell those industrial park sites. So they had a survey, and that's called the Dantzler survey, which we reference in the brief. Using the Dantzler survey, they were able to establish that northeast boundary. That property is under contract to be sold, so we would argue that that's finalization of those sites because they're selling those sites, and they've rezoned those sites. Those sites are rezoned industrial warehouse at this point. So those sites, as far as we're concerned, have been finalized. And again, there's no definition of finalization in the contract.
Hey, Counsel, didn't the agreement, didn't it account for that finalization?
Yes, it accounted for it precisely. The next line of the property's description says the eastern boundary, the 1,630-foot line, will be adjusted to ensure the acreage total. So it already had a mechanism within the legal description to deal with that boundary, which everybody knew was going to be corrected once those industrial sites was finalized, in order to make sure that my clients received the 65 acres that they contracted for.
So, Counsel, for our purposes, is there a difference between, we'll say, a patent ambiguity, or we'll call it that, and essentially the happening of a future event to determine a boundary?
We would argue that this isn't a happening of a future event, but yes, there is a difference to that as long as everybody intended, the parties intended for a specific piece of property, and there was a mechanism for them to determine where that property was going to be located. It's different if they say, you know, we're going to sell you property that we haven't received yet, or property that we don't know where it's located, but everybody intended this property to be located at this particular piece.
Of course, essentially that the boundary is going to be determined by something that you're all aware of, it's out there, but it just hasn't occurred.
Yes, and if you look at the record in this case, and the facts that we specify in our briefs, Greg Jones, who we argue is an agent of the Applees, he walked the property with our clients. He ribboned off the property with our clients. Our client, after what happened in this case is our client got this contract. The contract was signed by St. Mark's, and then he went down to the county to get a clearing permit so that he can clear some trees to build some things on the property to conduct his quail preserve. And the county said, we can't give you a building permit, or we can't give you a clearing permit because there's a permit to rezone this property industrial, the entire piece of property. And so my client went to Gulfstream's office, which is the engineer for the Applee. He pointed this issue out, and the engineer confirmed, yes, these properties overlap. This is an overlap. I was not aware of this contract whenever we submitted the rezoning application. Then my client, and this is all on the record, this is uncontroverted evidence, went to Dan Hill's house. Dan Hill is a representative for the Applees in St. Johns County. Went to Dan Hill's house, showed him the map. Dan Hill never said, this is not the property you're purchasing. You know, you're purchasing something else. He did not say that. He told him, we haven't got the property surveyed, that's what the holdup is, you know, and he actually sent an email, which we've put in our brief, to my client, which says, I met with the engineer and we've confirmed the acres to be yours. We're just waiting on the survey so that we can finalize the meets and bounds description.
Was that the April 2022 meeting? Is that correct?
Yes, at his house. He met with him at his house, and then there's actually 7 emails and text messages that were admitted into evidence where Dan Hill says, we will honor the contract.
Was that where, I guess, the deal went from 120 acres down to between 60 and 65 acres?
No, the deal went from 120 acres to 65 acres between the original letter of intent and to the binding agreement. The first binding agreement, it went down to 65 acres.
So the text message, April 22nd, 2022, Bowles received a text message from Jones stating that the new piece will be between 60 and 65 acres.
Right.
Is that a misnomer?
Sorry.
Is that a misnomer? Or?
No. After my client learned that the property was being rezoned from the county, Greg Jones began to prepare multiple different variations of the map and tried to get my client to accept those other variations. And so that's what he's doing in that text message where he's saying, you know, here's another variation which we would like to give to you it's going to be within the 60, 65, you're going to get your acreage, but it's just going to be in a different location. And that's our argument, is that if this isn't a contract, then why did they feel the need to go back to him and try to get him to agree to accept another location, if this is just a letter of intent or an agreement to agree? And again, if this is an agreement to agree, why does the $65,000 non-refundable? And why is there a closing date in it? And then why is there a lease in lieu of closing if this is just an agreement to agree? One of the primary issues that we have, which we've raised on this appeal, is that the final judgment is basically a verbatim copy of a proposed final judgment that was submitted by Appellees in this case. If you look at the findings of fact and conclusions of law following the non-jury trial that was entered by the court, once you get to the section titled General Facts.
I saw the Appellee's findings of fact and conclusions of law. Did your client submit corresponding findings of fact?
We submitted findings of fact, but not conclusions of law. The court, at the end of trial, asked us if we wanted to do written or oral arguments. We agreed to do oral arguments. After we gave our oral arguments, the court said he wanted us to submit proposed findings. He did not ask us to submit conclusions of law or a proposed final judgment. He specifically stated, I will do my written findings, and then at the bottom, depending on where my findings go, order one side or the other to either follow up with a final judgment. And the reason that's problematic is that if you look at the findings of fact and conclusions of law, the court's primary issue in this case is the patent ambiguity. And he says, because there's a patent ambiguity, there's no meeting of the minds. And if there's no meeting of the minds, there's no contract, and then all our other causes of action fail because we don't have a contract. But the final judgment doesn't even reference the legal description properly. It's factually wrong, and it's inconsistent with the evidence. The court states that it is undisputed that this agreement contains a definition of property, and the property contains 65 acres within the master parcel. That's factually a misstatement. It's 65 acres within the northwest portion of the master parcel, and that's important because that northwest section only contains 67 acres.
Well, the further description of within the northwest portion is more specific. That doesn't render the court's statement as incorrect or erroneous.
No, I don't think it's incorrect or erroneous, but I think it deserves clarification in this particular instance because the northwest corner is only 67 acres.
So then, and I read that in your brief, what is the legal consequence then of your emphasis that the northwest aspect of the description was overlooked? What's the legal consequence?
The legal consequence in our sense is that that northwest section only contains 67 acres. So there was a specific area that the parties intended to convey. This isn't just somewhere where, once we decide that we're done with the commercial permits or whatever in this land, you're going to get your 65 acres somewhere on this parcel. That's not the case. This was specifically agreed upon that this was going to be located in the northwest section of this parcel, which only contains 67 acres. So we're only talking about 2 acres that are going to be swallowed up whenever we determine what that northeast boundary is. And if there is a loss of acreage, then there's a specific direction that the eastern boundary is going to be pushed out to ensure that there's 65 acres.
If the trial court had found differently and determined that there was an enforceable contract and that property was to be conveyed, would the trial court have been left in the position of drawing the property lines?
I don't think the trial court would be in the position of drawing the property lines, but I think the trial court would be in the position where it can take the extrinsic evidence that was presented at trial and determine where the property was to be located.
And Mr. Lewis, you're in your 5 minutes if you want to reserve or keep going. Up to you.
I would just like to add one more point about the inconsistencies and the misstatements of fact that are in the final judgment. Another major fact, which again goes to the legal description, is that the court states that the actual legal description to be determined at a later date. That's not what the legal description says. It says a meets and bounds description to be determined, not an actual legal description. And that's important because there's no requirement under the law that a meets and bounds description be within a legal description. Thank you.
Thank you.
May it please the court, my name is Rusty Collins. I represent the appellees that are St. Mark's Pond and Daniel Hill. The focus, of course, has been on the legal description of what it meant in this case. First of all, the contract or the agreement that was attached to the complaint and what was fought about was not a letter of intent. It was meant to be a contract by the parties. The problem was we had sophisticated parties who do large deals making a 2-page agreement that should not have been done the way it was done. They did not use counsel. They took a shortcut, and it bit them both. The legal description, however, is very simple from the appellee's point. It's the property they can't use for anything else. They called it remainder land. And, you know, that word remainder land was defined in the contract or in the agreement. And it was 65 acres, and it says the exact meets and bounds to be determined after they get the industrial parcels from the north side defined. So,
Mr. Collins, your position is the meets and bounds aspect of this agreement or contract was absolutely necessary for there to be a binding agreement. Is that correct?
because you cannot point to this property by this lot or this address or the Esmeralda Hotel, because you can't point to it, you're going to need a way to describe it. If it was straight section land, you could say government lot 3, or you could say the northeast of the northeast quarter. There's ways to do that. Here, they had an undefined, the property was supposed to be generally in the location that's outlined on that Exhibit A. And of course, that Exhibit A says approximate approximate Bowles property or approximate location. I can't remember the words off the top of my head, but the point is, it was approximate. What was important was they had the industrial lots at the north end that had not been defined at the time of the contract. And whether or not the St. Mark's Pond was going to do something with the road that traveled down into the property, because there was a possibility that could be mitigated and actually used as industrial property, or maybe not. The analysis had not been done.
So it's also your position that the fact that Mr. Jones walked the property and ribboned off the property with Mr. Bowles, that's irrelevant?
There's a big question as to whether Mr. Jones was an actual agent for the appellees here. Mr. Jones worked with Mr. Bowles before he started showing him any property or any part of the property that we're talking about. He had been trying to help Mr. Bowles find a place for his quail preserve. And then now Mr. Jones and Mr. Hill were friends. Mr. Jones and Mr. Bowles were friends. The judge said that he was acting in the middle between the two friends. I mean, he wasn't really acting as a real estate agent. I mean, he didn't even use a real estate contract form. He wrote this thing up himself.
Well, was Mr. Jones given permission by your clients to walk the property and tape off the property as a representation as to what was going to be conveyed under the contract?
I do not believe that was in the evidence, and I don't believe it to be true, but I know they walked the property. How could Mr. Jones go out and say, this is the property you're buying, when they didn't have the industrial lots outlined yet?
So let me ask you a question along those lines to build on what Judge Wallace is inquiring about. If I assume you agree with the trial court's conclusion that the contract is ambiguous as to what property is to be conveyed.
It is, yes.
So if in our review of the trial court, if this court accepts that conclusion, and the contract or the binding intent to purchase and sell real property agreements at page 1373 and 74 of the record, and of course the attachments included, I think, at page 1372, that was signed December 31st of 2020. And the closing date is just a week later, January 7, or 30 days after the release of the mortgage on the affected parcel, correct?
That's correct.
And if that is not met, then of course the property is to be leased, is that right?
That's correct.
So my question is, if there is not an appropriate indication of the property to be sold, what property is to be leased?
It would be whatever property that's to be sold. That's the problem. They did this fairly quick, as far as I can tell, and, you know, once the, from the appellee side of things, they were working to get property rezoned and then figure out where they could get the industrial lots on the north, and then this would have been just fine. And they would be making their analysis along the way. When it came up that the appellant decided that they didn't want them to rezone anything, you know, if you go to rezone, you're dealing with a parcel number from the zoning people, and until you get a cutout, you're zoning, you know, you're working on the whole parcel. And that made...
But if the zoning and the industrial sites and things of that sort still have yet to be determined, and that is in progress, and there's no description of the property, let me reiterate the question. What is there to lease at that point? If you have to close in a week, January 7 of 21, or 30 days after the release, and of course that's going to take some time.
That's correct.
How could there be a commitment that we're going to lease? There must be a sufficient identification of the property. If there's an agreement, we're going to lease it. Is there not?
You can find 65 acres in that general area that he could be working on that would not come into play. The problem was, from the appellant side, what was on that Exhibit A or that attachment in red was what he thought was the exact property he was buying. And if that was the case, it would be fine. But of course, from the appellee side of things, we still had to get the commercial use determined. And until that was done, you don't have a good legal description.
Then why did they sign the agreement knowing that that was out there? Again, isn't that just essentially a contingency that's got to happen before the exact metes and bounds are determined? Why was that unclear? I guess that's my confusion. Yes, I agree. That's exactly what the agreement says. It says Bull's proposed purchase area. It explains it, and it seems reasonable that the description attached to the agreement, you're calling it a contract, attached to the contract that's outlined in red, that he would think that's what he's buying. So the fact that the industrial area wasn't yet determined, okay, so that's going to be in the very corner of this outlined red area. Okay, why does that make it so confusing that the property lines can't be determined?
Well, depends on where you think the eastern property line goes. The IME survey has the eastern property line, or the northeastern area of the property line, pretty much following the road that goes southeast, whereas the original outlined area on that map does not do that.
And I may be wrong, because I know there are several surveys. Isn't this the survey that the difference is like 40 feet or something like that?
The perimeter difference is very negligible, and the acreage difference is negligible.
But the shape
However,
is different.
The shape is much different in certain areas. And you have to understand, if you go down the road, there's some usable property that might be, or the property that might be usable down that road. You may have to mitigate it to get it usable, but they didn't know whether it was going to be usable or not. But in the map that everybody says Greg Jones did, that easterly line does not follow that road like it does on the IME survey. There's a huge difference there, depending on what you're using it for. If it's all going to be mitigated, it doesn't really matter, because you're not going to use it for anything other than conservation and bobwhite quail. The problem they had was there was an immediate disagreement about that. You know, Mr. Hill kept saying, we will honor the contract, because that's what he meant. The contract says as soon as we find, in his mind, the contract says as soon as we figure out where these industrial lots are and whether we can mitigate the property down that road, we'll know what's left over. And that will be remainder property, and that's yours. That's where the agreement between the parties started to fall apart. Then the question is enforcement. You cannot look at that legal description that's on the agreement and determine where that property is actually located. Yes, it says northwest. Northwest from where? Okay, I know there's kind of a area that goes northwest in that area, but the shape of it is quite a bit different depending on how you look at it. And
What was the consideration that your client gave for purposes of this contract?
the consideration.
Specifically, my question is, 18 months after allegedly this contract was signed, you had $65,000 from the appellant, and still, to that date, no consideration from your client as far as the terms of the contract.
If the record that we have shows that St. Mark's Pond immediately started trying to find out what the highest and best use was for the property, the northeast or the northern industrial lots, whether or not they could do the other mitigation down the road. Did Mr. Bowles receive anything? No. The only consideration was trying to get this deal done. And from my client's perspective, Mr. Bowles kind of fought him on it because he wouldn't let him get the rezoning done. He wouldn't let them get stuff done. And that's where their
Isn't that all
relationship-
extrinsic evidence?
That is extrinsic evidence.
So it's not in the record on appeal?
I think it is on the record on appeal because there's the emails back and forth and the fact that that was a lot of what was going on in the 4 days of trial was what the Hill family did trying to get the property rezoned, or when they were trying to sell the northern acreage. They were trying to do certain things. It didn't work out because they were stopped by the appellant. And I think there was just miscommunication. Otherwise, they could have had this all done by now. But when you get down to it, with that miscommunication, you have, is this contract binding? Is there a defect in it? And the first part of looking at whether there's an ambiguity is, can the court look at the words and find the property? Now, I'm not saying that the court has to look at the words and find a meets and bounds description, but can the court look at the words on the paper and find the property? Well, it does say northwest, but it also says after the industrial parcels have been determined. That was not done at the time of the contract, and it's not been done since completely anyway. So the court cannot look and see that because of that ambiguity. It's a huge parcel, it's a 218-acre parcel, I believe, and we're trying to talk about 65 acres. You can't say it's the northwest quarter of this thing. So the court can't look at it and say, this is where it is, now go get me a legal description from a surveyor. I think if you could identify it, then great. Then you could use the extrinsic evidence or a surveyor to actually define it, so you could have a specific performance order. But here, we don't have that because it says that the real location of this property is going to be determined after those industrial sites have been determined. And that's the basis of the whole argument here. The court below did ask the parties, and I don't know how important this is to the court, but Mr. Lewis has talked about it quite a bit. The court below asked the parties to send in proposed findings. At one point, I asked, you want proposed findings of fact, conclusions of law. The court said yes, but then he kind of backed off and says, I'm going to rewrite it anyway. Okay, I'll copy, paste, edit, do what I want. And both sides sent in their proposed findings. Mine has a judge's signature line at the end of it, and the other side had Mr. Lewis's signature at the end of it. But his findings had conclusions of law and proposed judgment language, just like mine did. The court took my arguments anyway, but the court did not take what I wrote verbatim. The court edited quite a bit. There are some vast differences as far as some of the comments that I had written and what the court did. And there was never any ex parte communication between me and the court. And I can't imagine why there would be. But, and we were both supposed to send the proposed findings by a certain deadline. And the idea was, I think the court said something about, he didn't want one person to send it in and the other person react to it. He just said, both of you send in your proposed findings and I'll deal with it. That was our closing argument. My analysis in there was my closing argument. And what the court chose to accept was what he agreed with. But the case goes back to, was there a patent ambiguity in the legal description? We believe there was. And for that reason, specific performance doesn't work, but that patent ambiguity cannot be fixed because that destroys the meeting of the minds. If there was a mutual mistake as to what the property was, or even a unilateral mistake as to what the property was, that destroys that proverbial meeting of the minds. Without that, they were not talking about the same thing. I think they both wanted to do something for the bobwhite quail. It had some benefit to both sides because, the regulatory people do like it when you have something like that on a property. And this was something Mr. Bowles liked to do, and that's all admirable, but they did not have a good grasp on where that property was located. And the dispute was from those northern lines, and also it went down that road. If it wasn't for that, they probably would have been done by now. But they did not describe it adequately enough. There's also been a lot of argument as to whether, well, I think I talked about that, Mr. Jones's efforts. And Mr. Jones is an independent real estate person, but he worked with both of them. He was friends with both of them. But for these reasons, I believe the court should affirm what the trial court did. Thank you.
Thank you. Got a little bit north of 4 minutes.
Thank you. I just want to touch on a couple of points that were brought up. The court's decision that there was no breach of contract because there was no contract was based on the meeting of the minds. The reasoning for that was he stated that the legal description was subject to multiple interpretations. But it's our position that that's not enough. It's not just enough to be capable of different interpretations. The evidence must show that the parties must, in fact, interpret the contract differently. And that's Goodman v. Goodman, which the appellees cite as well, 290 SO2D 552. In this particular case, James Hill signed the contract on behalf of St. Mark's. At trial, James Hill testified that he believed that the contract was binding and that he believed that the property that they were to sell was located within the red outline that was contained on Exhibit A to the contract. So both parties in this case believed the same thing. They interpreted this contract exactly the same. It was with the property that was to be conveyed was within that red line that's attached to the map on the contract. The only thing that changed, or was subject to change, was that northeast boundary once those industrial park sites were surveyed, which they have been surveyed. Another issue is the agency of Greg Jones, and the reason that's an issue is because Greg Jones, it's undisputed that he drafted the contract. And so now the appellees are trying to get out of the contract by saying that the legal description is ambiguous when they're the ones that drafted the contract, because Greg Jones is an agent of the appellees. He's an officer and a director of Notre Dame Investors, which is the management arm of St. Mark's Pond, in both Florida and Arizona. He testified that he received payments from St. Mark's. He actually entered into another listing agreement on behalf of St. Mark's right after this property was supposed to be closed for the same exact property. And the listing agreement was with Property Theater, and he signed it as the vice president of St. Mark's to sell this exact piece of property underneath my clients. And the listing agreement contained the same language, that a meets and bounds description will be determined. This issue that the parties do not know where it's located until the commercial permits are exhausted or wherever they figured out what the highest and best use of the property. We believe this is not a sincere argument. The language contained within the contract states that has language in it that says once the property is no longer valuable to the appellees, but we believe that that's surplus language. It doesn't necessarily define where the property is located, because the legal description specifically states the property described herein, which will be, not useful to the clients at a later date. That doesn't say where that property is located. It's surplus language, and it's consistent with the language the Fifth District Court of Appeal decided in the case that I cite in my brief, Bajrangi versus Magnethal, 589 SO2D 416. That's a 1991 Fifth DCA case. In that case, there was a lease with an option to purchase. The option had a legal description in it, which had the street address for the property, and then it also contained, in quotations, other surrounding property. And in that case, the trial court said that the legal description was patently ambiguous, but it was reversed on appeal. And it was reversed on appeal because the court, in citing the Simons v. Tobin case, said, in the case that writings showed that the parties were dealing with regard to a parcel of land identified by them, but by no means certain in point of description, yet parole evidence was held admissible to apply to the description used in the writings to the particular tract in regards to which they contracted with each other. And the court found that the legal description was written by the appellees, and therefore they were stopped from claiming it didn't apply. Thank you.
Thank you, Mr. Lewis.
Thank you.
All right, thank you, counsel. The next case we have is Kimberly Ann Reese versus the